party line to support this amendment. With this, I conclude.
Thank you. Sri P.B. Chaudhary.
धन्यवाद सभापति महोदय, आपने मुझे एक बहुत महत्वपूर्ण बिल पे बोलने का मौका दिया. Sir, the amendment on the face of it, so that it is a small, but the implication of this amendment is larger, and basically the government has taken the cognizance to redress the grievances of all those people whose judgments were given after 2008 in the state of Nagaland and after 2019 in the state of Himachal. So the government is cognizant of this fact, and I rise here to support this amendment. Sir, basically the amendment is with retrospective effect, and the parliament is competent to enact such type of law with retrospective effect to validate all the orders, judgments given by those courts which were established in 2008 in Nagaland and 2019 in the state of Himachal Pradesh. So I fully support this amendment, and this amendment can be with retrospective effect. But I would also like to say that this amendment is basically for establishment of the court by way of notification is within the domain of the Government of India. And now the Government of India is bringing this amendment under Section 1(3) because this court are required to be established at the relevant time. Since it was not done, therefore it is being done. Now the proviso has been added under Section 1, subsection 3 of this bill, whereby the court has been deemed to be established with effect from the date when the respective state government established these family courts in their states. So with effect from 2008 and 2019 with respect to the state of Nagaland and with respect to the state of Haryana, Himachal. Now, sir, this I would like to also suggest about this, because during this period the thousands of orders and judgments have been given, and all these orders shall deemed to be validated. Even this is suffice. Without any validation, without any further order or without any further amendment, validation under Section 3A, once you establish the court with effect from the date when the courts were established in respective state, then all the judgments shall deemed to be validly passed by the competent court having the jurisdiction to pass the same. Now, Section 3A, this certain, I would like to clarify, under Section 3A, validation of the certain action, whereby the Section 3A 1, 2, 3 and 4 were added. But for the purpose of clarification also, I would like to want clarification from the Honorable Minister that in subsection 3 of the 3A of the subsection 3, it is mentioned that every order of appointment of a person as a judge of a family court and every order of posting, promotion or transfer, as the case may be made under this Act in the state of Himachal Pradesh and Nagaland prior to the commencement of the Family Court Amendment Act 2002 shall be deemed to be validly made under the provision of this Act. Here I have some suspicion and doubt about that whether this provision will extend this judicial scrutiny or not, because suppose some cases were pending with respect to the promotion of a particular individual, with respect to the transfer, and if that particular court of competent jurisdiction quashed that promotion, then there will be this analogous situation. So in my view, this provision is superfluous and it creates a confusion, and I don't think it is needed for it. If the purpose is served by providing establishment of the family court under Section 1, subsection 3, then such type of provision is not required. And at the same time, apart from this, I would also like to make it clear that in judges, for appointment of the judges, High Court and Supreme Court, no doubt the involvement of the Government of India is there, involvement of the High Courts and respective High Courts and Supreme Court is there. But for the appointment in subordinate judiciary, it is for the respective state government and the respective High Courts. large number of vacancies are available, and on account of the availability of the vacancies, the area of cases are there, and in family court also, the parties are suffering hardship. And just now, this Mehtab ji has stated that around for 30 years, the cases in the family courts were pending. So this is situation not only in one state, but this situation is available and prevailing in other states also. Therefore, the time to time, no doubt, the government of India has issued the advisories to the respective state governments and the high courts for making the appointments and filling up all the posts of the subordinate judiciary in their state. Because in family court, only the officer from the subordinate judiciary can only be appointed. So once the vacancies are filled up, then the agony which is families are facing on account of justice is not imparted timely, it is not imparted timely, then that can be redressed to a greater extent. And at the same time, sir, I would also like to say, because Nishikant ji has raised the issue with respect to the NJAC, so I would like to add that under Article 366 of the Constitution of India, which is basically a definition clause, it defines various words used in the Constitution of India, but at the time of the framing of the Constitution of India, the word consultation was also used. The word consultation was used at so many places, at least 18 to 19 places in the Constitution of India. But at 2 places, where the appointment of the High Court judges and Supreme Court judges is mentioned, the word consultation has been defined by the Supreme Court that consultation means the concurrence. So whenever the President of India is taking the consultation from the Supreme Court of India, then that consultation is treated as binding. But the consultation appearing, the word consultation appearing in so many other provisions of the Constitution of India, that is not binding. No, the analogous situation has been created. Now, in view of this, it is the right time that we have to bring an amendment in the Constitution of India under Article 366 of the Constitution, wherein the word consultation is required to be defined as whatever the word definition is given in the dictionary meaning. So natural dictionary meaning should be placed there. The word consultation is not the concurrence and it is not binding, and once it is there, then the power of the government, which has been given at the time of the enactment of the Constitution of India, shall be restored, and the power of Parliament shall also be restored, which is a supreme body for enacting the law. Thank you very much, sir.
Thank you. Anubhav Mohanty, Sri Anubhav Mohanty. Last speaker, I think.
Thank you